Speak English, sir.
Yes, English.
Mr. Castro, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 3rd, 2025, in Harris County, Texas, a law enforcement officer computed information about a street takeover event and went to the location that was put on social media.
Whoa, straight into the courtroom drama. Mr. Castro is facing up to 30 days in jail for reckless driving. Fun fact, in Texas, reckless driving can also include performing stunts like donuts in crowded areas. Judges don't mess around, especially when social media shows the chaos firsthand. What would you do if cops saw you spinning out in front of parked cars? Drop your thoughts in the comments.
The law enforcement officers conducted surveillance on the location and an unmarked vehicle and witnessed a vehicle making donuts and get within close proximity of several parked occupied vehicles. Law enforcement officer initiated a traffic stop on the vehicle and detained the defendant, the driver of the vehicle.
Any prior reckless driving cases, and then can you see if he has a license, please?
There are no prior reckless driving cases, Judge. There was a DWI and an evading vehicle at Dalton County. Just
At Hidalgo? Okay. Anything else?
And driver.
Living in a city like Houston without the ability to drive, that's basically being stranded in the wild. And here's the kicker. Officers can seize your car permanently. Imagine losing a $100,000 car just for one reckless stunt. Would you risk it for a few adrenaline-fueled minutes on the streets?
Okay. Mr. Castro, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now not to participate in this activity anymore or drive recklessly, maniacally. If I find that you do, the first thing I'm going to do is put you in jail. And the next thing is I will take your ability to drive away from you while this case is open. Do you understand?
Yes, sir.
Living in a city as big as Houston without the ability to drive blows. Not only that, people who participate in these types of activities, cops and DA's office can seize and take your car away from you permanently. And I've seen it happen on multiple occasions where people lose their $100,000 car because they... Do you understand?
So,
You put bond conditions, no donuts, street takeovers, reckless driving, racing, etc. Please. Mr. Castro, do you have the ability to hire a lawyer? We're going to give you time. So I'll have you go to Ramona, sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions. Do not leave until you sign the bond conditions. After that, we'll let you go. When you come back, please have a lawyer.
Judge, I apologize. Did you say no driving or just no reckless?
No reckless driving, donuts, street takeovers, racing, and all that. Is it Ashika Jackson?
Yes, sir.
Man, you trial and or $4,000. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. But you right to remain present if you cannot afford one.
Okay.
Thank you, Judge. On March 26, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. The officer met with the complaining witness who stated that the defendant is from a roommate. The complaining witness stated that they got into an argument over a broom and the defendant struck her on the head with the broom, causing pain. The officer observed a raised bump on the complaining witness's head that was starting to become discolored.
Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this complaining witness. You're also ordered not to be in possession of weapons. If you violate this order, I'm going to put you in jail. No more PR bonds. Do you understand, ma'am?
No, sir.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they can file additional charges against you, a violation of a protective order, and that is the capital murder of misdemeanors. Do you understand? It's one of the worst cases you can pick up. So don't violate the protective order.
Okay, yes, sir.
Okay. Would you like, do you have the ability to hire a lawyer?
No.
Okay. I can appoint you a lawyer to, or I can have you fill out an application. Let me see if you filled one out first. Hold on. I have an application on file already. I have it on file. So what I can do is I can appoint you a lawyer today. We're going to create bond conditions for you. Do not leave until you sign those bond conditions. Otherwise, I'll issue a warrant. The bond conditions, no contact, no weapons.
Okay.
All right. For now, I'll have you go to Ramona, sign a reset, and then we'll have you take your seat in the jury box.
Okay.
Now this is intense. Mr. Gomez is on felony probation for aggravated robbery in another county. That's serious business. 20 years potential prison time. The judge is laying it out clearly. Pick up more cases and probation revocation is almost guaranteed. This is where understanding how prior offenses interact with new charges becomes crucial. Ever wonder how one small choice can cascade into major legal consequences?
All right. Good morning, Mr. Gomez. So he's got two cases, right? The trespass and the DWI?
He got time served to the DWI. They're dismissing the criminal trespass.
Now, if I'm correct, you're on felony probation in another county, right?
Yes, Your Honor.
Is it?
It's Bear County Judge's aggravated robbery.
You're looking at 20 years in prison, you know. Not only that, it's a 3G offense, meaning that if they revoke you and send you to prison, you have to do half the time before you're even eligible for parole. So if they send you to 12, you're doing 6 before you're even eligible. Now you got these two cases. When is it going to register to you that we mean business, that you can't continue like this, unless you want to go to prison, of course. You need to understand that by pleading guilty to these cases here now, they may use this to revoke your probation in Bear County. Do you understand?
Sure.
Now, I don't know if they're going to, but they can. And I'm going to tell you, the more cases that you pick up, the higher likelihood you have of that happening, because they are going to be like, well, this guy just, doesn't take us seriously.
Sure.
You are giving up a lot of rights by entering into this agreement, Mr. Gomez. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the rights to appeal. Once you accept the changes or undo this, when you're in a car and you're driving and you get pulled over, the first thing an officer does is they look at your criminal history. If they roll up to your car, they look at and they see that you're on probation for an aggravated robbery, you have been charged with a trespass and a DWI, and they come up to you. You think it's going to go well? So I probably wouldn't give them the ammunition from now on. If you want to get lit, don't get into a car. Even if you've had a sip of alcohol, you understand.
Yes, sure.
As part of the agreement, it's 20 days in jail on the DWI, 16 days credit, and they're going to dismiss the trespass. Is this how you understand it? You also, I'm going to make a docket notation that I have advised you that by pleading guilty to these offenses, it's possible they will revoke your probation in Bear County. Do you still want to do this, or do you want to wait to see what happens over there?
To do this.
You want to do this?
And he's been in communication with probation over there, Judge. And basically, they gave him the option of either being unsatisfactorily terminated. Is that correct, Mr. Gomez?
Yes, unsuccessful.
Or he can have it extended and attempt to get it successfully terminated. And so he chose to have it extended to pursue that option. They were already aware of these cases, correct?
Yes, sir. Yes.
How do you plead to the driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to the agreement. I'm going to suspend your license for 180 days. Do not drive. Otherwise, you're going to be right back in jail.
Sure.
All right? Good luck, sir.
Thank you, Judge.
Good morning, Mr. Reyes. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
25 in Harris County, Texas, an individual notified officers of a motor vehicle stopped on the roadway. The officer observed the vehicle stopped in the intersection between two lanes. A traffic stop was initiated and the officer observed the defendant behind the wheel, leaning over with his eyes closed. The officer woke up the defendant, and the defendant did not acknowledge the officer's knocking on the motor vehicle, and the motor vehicle began to move.
Here's a pro tip straight from the courtroom. Bond conditions are your lifeline. No alcohol, no illegal drugs, and yes, random tests. Fail to comply, and it's back to jail with no PR bond safety net. The judge is making it crystal clear. Your freedom depends on following these conditions. Could you imagine having to constantly prove you're not breaking the rules just to stay out of jail?
The motor vehicle fled for approximately 2 miles, stopping in front of a residence. The defendant exited the motor vehicle and was handcuffed. The defendant stated he did not see the officer with lights on behind him. The officer observed the defendant come to a complete stop in designated areas to properly use turn signals. The odor of alcoholic beverage was emitting from the defendant's person. The defendant stated he drank 3 to 4 beers. He was identified by Texas driver's license and 606 clues on the HGN, walk and turn, and 204 on the one leg stand. Defendant considered to do a breath test and blew 0.15 and 0.147.
Okay. Any prior DWIs?
No, Your Honor.
License?
Eligible.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, you pick up a new case, you become a danger to my city, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance. That's also a condition of your bond. You have a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Zaman. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You understand your conditions?
Yes, sir.
I'll have it. You're free to go.
Thank you, Judge.
Please. So you're charged with driving while intoxicated. Second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 4th, 2025, in Harris County, Texas, officers were dispatched to a traffic hazard call. A motor vehicle was stopped on the shoulder of the freeway, slowing down traffic. The officers observed the defendant sitting in the parked motor vehicle, and the defendant immediately driving the motor vehicle to the location and being its registered owner. The officer detected a mild odor of alcoholic beverage, clear, glossy eyes, and that the defendant was not sitting outside. Standardized field sobriety tests were conducted, and the officer observed 606 clues on the HGN, 1 out of 4 on the one leg stand, 2 out of 8 on the walk. The defendant refused a breath test initially, and then eventually consented to a breath test. The results of which were 0.118. And
He's just sitting in a parking lot? Does an officer see him at all when?
Sorry, Your Honor, he was stopped on the shoulder of the freeway.
Oh,
slowing
okay.
down.
Got it. All right. Okay, Mr. Weissoon, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now, does he have a valid license?
Yes, Your Honor, he does.
Okay, I'm now placing a restriction on your license. I'm now ordering you not to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand? I don't care what you have to do, where you have to go. If the car doesn't have an interlock, don't drive it. We are sending notice to DPS in Austin so that every single officer in this state knows. So if you get pulled over, they're going to know that you need one. If you don't have one, they're going to take you to jail. I'm also ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. Because you have a lawyer.
He already has the interlock on the car, Judge.
Great. Okay, so just provide proof to them, or they should be able to look it up, and then we're all happy. Just don't use. You understand? Because you have a lawyer, I'm going to waive your appearance. You don't have to waste your time coming to court, but stay in touch with Mr. Bresson. He'll tell you if and when you have to come back to court. So if you pick up a new case, if you're a danger to my city, if you just, it's not going to go well for you. Do you understand? Okay, guys.
Thank you, Judge.
Please.
Permission to approach you.
Yes, please.
Your Honor, I'm here on Shamar Anderson. So I just wanted to approach on this one. I was talking to the coordinator. It is an older case.
It's nearly, it's 370 days old.
So he doesn't live in Harris County, Your Honor. And so that's what really kind of has led to the delay. So I just got appointed today. I would ask for at least 30 days to be able to review everything.
I mean, I'm not gonna, this case is 400, he's taken off on multiple occasions. Is there an offer in this case?
There is a time served, Your Honor.
Is that it?
They haven't talked to the complainant, Your Honor. They haven't called the complainant.
We've not made contact with the claimant, Your Honor.
I'm getting my ass chewed because of all these cases that are so darn old, so no more. So I'll give you guys 2 weeks. You need to get in contact with the complaining witness if it's needed, because I don't know.
It is late.
So you've got 2 weeks,
Yes, Your Honor.
so no more. So get on it, and then he's gotta be back in 2 weeks and it's clear trial on that day.
Friday day?
370 days old. I mean, really. I have to say when at some point. I can't just keep letting it go.
Well, can I ask you this, Your Honor? Since he does live in San Antonio, that is our, can we get 3 weeks?
Come up.
I just want to make sure, I don't want to create an issue with him and his travel. So I just want to be clear with the court. I understand, Your Honor.
Literally, Mr. Anderson, you literally bend over backwards to not put people in jail.
Sorry.
Your case is nearly 400 days old and it's time to make a decision on what to do.
sir.
I'm not going to sit here and play any more games.
Yes, sir.
2 weeks for you guys to meet to decide what you want to do with this case.
Sir.
But at 370 days, that's it.
2 strikes already, and Mr. Nava is testing positive for alcohol again. The judge is sending him for a drug and alcohol test. Miss it or fail it, and it's an automatic warrant. This is high-stakes accountability in action. Court isn't just about punishment. It's about showing the system you respect the rules. What would you do if you were in his shoes?
Cases should be resolved at 180 days.
Sir.
Do you understand?
Sir.
So be back here in 2 weeks. Let us know what you want to do. You must meet with them to figure out, look at the evidence, see what's out there, and just make a decision. It's not hard. It's a trespass. It's not a capital case, you know? If it was something serious, then yeah, but I mean, it's a trespass. It's not a capital trespass, you know? Okay. All right, guys.
Honor, if I may, this stems from a bond violation report here where there's 2 readings of positive alcohol on his portable device that he currently has, Your Honor. I've discussed this at length with our client, and as you may understand, in our experience, we certainly hate to provide any type of excuse whatsoever when it comes down to this. Discusses with our client, he's adamant that this was stemming from consumption of medication during a period where he was unfortunately under the weather, Judge. And he did send me the pictures of the medications that he consumed. It's Theraflu, Dayquil, the typical over-the-counter medications, Your Honor.
None of that is going to test positive for alcohol. You know?
I made it abundantly clear this should not be something that, should even come out like this way. This is something that we would graciously ask the court here to consider seriously admonishing our client, Judge, but allowing him to remain on bond. I think we're close to a resolution on this case, Judge, and we're looking to hopefully get this resolved as quickly as possible.
Here's what I'm going to do. I'm sending you now for a drug and alcohol test. I've ordered you not to use. We've had pre-trial tell you not to use. And you now have on 2 different occasions tested positive for alcohol. So either you don't care about court orders or you have a problem. I'm sending you now for a drug and alcohol test. You were to come back, and it's now late, so we'll have you come back Monday with the results. Do you understand?
Entiende.
Okay, I'm sending him now, Mario, and then we can regroup on Monday, okay?
That'll work, Your Honor. Thank you.
Wow, yeah.
Okay.
You're always
Thank you,
come
Judge.
back here Monday, and I'm sending you for a drug and alcohol test. If you fail to take the test, I'm going to issue a warrant for your arrest. Do you understand?
La su arresto. ¿Entiende?
You're to come back Monday, and then we'll discuss the results. If you fail to come back Monday, likewise, you will be arrested.
Será registrado.
Okay? Take a seat for me, sir.
Basically, Your Honor.
Thanks, Mario. See you.
We can judge. Take care.
Hi, Mr. Sweat.
How you doing, sir?
How are you?
Pretty good. How about yourself?
What's the word?
Judge, so he's been cleared now.
Great.
My understanding, well,
I do have to advocate for my client, Judge. When he first
I'm
signed
not
up,
going to begrudge you for advocating for your client. Absolutely.
when he first signed up, I admonished him. We went through the paperwork. We talked about what to expect. He was expecting a pickup date of April 16th. And so all of a sudden, he wasn't cleared medically for some reason. We
Well,
don't.
because he was allegedly coming down, right?
I don't know who makes that determination.
If you're in a state that it's not an appropriate state for transport,
Right.
he's subject to injury to himself. Transport, it's a huge liability for them. So they want to make sure that you're in the right state of mind for when you do get transported. I mean, it's only logical because the last thing they want is to get sued because they try to take you and you're not in a right condition and something happens, right?
Sure.
Do you know that every time someone comes to transport you from this state to the other, it's $4,000 to $6,000. It's not cheap.
Sure.
Someone has to pay for it, right?
Yes, sir.
A lot of times they'll come after you to foot the bill. So I don't know. But regardless, it's a 30 days, right?
Correct, Your Honor.
When are they coming?
They said they can be here with up to 10 days. So the reset date is the first, but they should be here.
What is it?
The reset date for this case will be the first for
Okay.
3 days, but they probably should be here without thinking about up to 10 days.
Okay. So it's still within the 30, right?
Correct, Your Honor.
Okay. I mean, it's still within the 30, which is what the statute says. So no one's doing anything to you that would harm your interests in any way. We want to make sure that you can be done in a safe and effective way,
I understand.
So hopefully within the next 10 days.
Here's some courtroom behind-the-scenes insight. Pre-signed waivers, extradition windows, and reset dates can be confusing, even for lawyers. The judge calmly explains that what looks like 14 days is actually 30, statutory courtesy at its finest. Legal processes can be tricky, but keeping track of the timeline is everything. Ever been caught off guard by fine print? Welcome to the courtroom version.
Hopefully, Judge. Yes. Okay.
Okay. He has a pre-signed waiver anyways, right?
Yes, and it was entered on the,
Even if I wanted to give him a bond, I can't.
Judge, the only thing the issue
Sign waiver.
that brings up though is we require him to sign the waiver of formal extradition and everybody signs this.
No. There's a document that I signed ordering
Did Hugh Hunter?
to be remanded. There's no real formal document for him to sign. It's a document that they filed to me and I signed it for him to go get picked up. So theoretically, there's nothing for him to sign.
What I'm speaking of is the actual waiver of formal extradition proceedings that's signed by him, by
They
you.
probably signed that because they didn't see that there was a pre-signed waiver to begin with, a lot of times.
Right. And that's my only issue. And we're talking about